Now call forward the attorneys in 124412, City of Wichita versus Gabrielle Griffey. Harper.
Thank you, Your Honor. Again, Kurt Harper, appearing on behalf of defendant appellant Gabrielle Griffey in this appeal from a municipal court, a criminal action in Wichita, Kansas. I appreciate the court's taking time to first accept the petition for review and then also particularly to hear argument in this case. It presents, we think, some really interesting aspects of First Amendment protection and how that collides with the efforts of the city of Wichita to regulate certain kinds of speech and certain kinds of conduct, both expressive and not expressive. On July 29th of 2020, Gabrielle Griffey participated in a demonstration that she had helped organize in Wichita, Kansas, to kind of fall into line with the series of Black Lives Matter protests that were occurring nationwide at the time in response to the killing of a suspect in Oregon. She was engaged in this process. The Wichita police were aware of the expected protest. They had determined not to interfere with the protest. They actually accommodated some of the protests by initially shutting down some of the traffic. And then she was arrested not during any segment of the march that she conducted, not during the period of time that she was making a loud protest speech on the steps of the federal courthouse, but she was arrested later. There are charges of unlawful assembly, which is a city ordinance that requires at least 5 people to develop a purpose to engage in certain types of conduct under the disorderly conduct ordinance. And it's that ordinance that then becomes the heart of what's wrong with what the city of Wichita did with Ms. Griffey and is allowed to do with the existing ordinance. It's the breadth of the kind of conduct that that ordinance attacks, which includes a wide spectrum of protected conduct that is intended to be expressive, that creates the problems that are irreconcilable problems in the context of the city's efforts to enforce the law.
Enough from your perspective in order, which I assume is to invalidate the ordinance. We simply can find that this ordinance makes illegal constitutionally protected speech. That enough for the overbreadth argument, as opposed to needing to also find whether it's content neutral or content.
That's kind of driven by whether this is really a speech case. And the city indicates that the prosecution is not based on the content of the speeches delivered during the protest or conduct. We are proceeding on the basis that this is a conduct, an expressive conduct case. And there are cases that suggest in this context, there are 2 things that need to be shown, but they tie in with your question. We have to show that a substantial portion of what is prohibited is protected conduct, so expressive conduct, and that in the case of noisy conduct in this particular ordinance, it is not feasible to sever its impact on protected conduct and unprotected conduct. So we have kind of a 2-step part of what we have to do, but those are inherent in the terminology used in the ordinance because one cannot violate the ordinance without implicating speech and intent and expressing yourself in a way that may cause controversy. Because part of the standard is that the noisy conduct to be the subject of the prosecution involves speech that will anger, alarm, or perhaps most broadly and most threatening, cause resentment on the part of somebody. And then when you look at the kinds of things done here, it was plain and simple, a political protest, a social protest, if you will, against the brutality that had been experienced recently and was the subject matter of similar demonstrations across the country. Now, what happened in this case that unfolds the story and helps to demonstrate how broadly this ordinance offends the First Amendment? You can consider the 2-hour video that the city presented as a core part of its case at trial. It's kind of the 21st century equivalent of 27 8x10 color glossy photos, because there's this whole array of things that are details that ultimately mean nothing to the case. Because if we take the city at its word, it isn't prosecuting Ms. Griffey for anything she said. It's hard to tell that they're prosecuting her for the amount of noise generated by the march. It's hard to tell that she's being prosecuted for anything other than the fact that during the course of the march, there was an interaction between one of the other members of the group and one driver of a car in an approaching lane who was concerned because a protester had stepped in front of the car.
Is that what precipitated the filing of the case?
Well,
It's hard to tell. I agree with you,
yeah,
but it seems that, but that's highlighted throughout, and there's photographs of this white vehicle bumping or
Yeah.
nudging and kind of.
But this is not an as applied challenge, correct?
correct.
So the facts of this case are really pretty much unimportant.
Well, they are unimportant in one sense, but the city's response to the position the defendant has taken is kind of a reverse as applied argument. The city takes the position that because they are not prosecuting Ms. Griffey because of things she said this time, it's okay. The ordinance should be upheld, when in fact, the breadth of the ordinance necessarily is such that you can't really enforce it unless you are worried about that content. Back to your question, what even brings this on? And the city has pointed out there's 2 ordinances involved, and that's part of why this becomes problematic. The first ordinance, the one that is actually the basis for the prosecution, is unlawful assembly. And that unlawful assembly ordinance requires that the defendant, as part of a group of at least 5 people, develop a purpose to do something else, develop a purpose to do something bad. And in this case, a purpose to engage in disorderly conduct.
That's not how I understand your argument at all. And maybe I'm wrong, because it's your argument. But it was my understanding that really focusing on 5.24010 disorderly conduct, that you're really focusing on subsection C, not the fighting words, but that engaging in noisy conduct tending to reasonably arouse alarm, anger, or resentment in others is overly broad on its face.
Yes, and that is our argument. But responding to Justice Rosen's question, because the city points out the prosecution is for unlawful assembly, which requires a purpose. And the purpose that the city has identified is a purpose of interfering with traffic and making the police force tired.
Well, if what you're talking about, what is, if restraint on speech is not content-based, the government must show that it has an important interest, right? And that its restriction is reasonable in terms of time, place, and manner. So are you talking about what is the important interest? What is the city's interest, right? Is that what we're talking about?
We are talking about the language ultimately, because again, the primary ordinance of unlawful assembly requires disorderly conduct. And in this case, that is limited to the noisy conduct allegation. The claim that there was noisy conduct is defined in the ordinance. And so the question is that regulation one that is so broad in its scope that it threatens protected communications?
Can I ask you a question about how you read the municipal ordinance? There's an introductory section that defines disorderly conduct. and basically that the person knows or should know will alarm, anger, disturb, or provoke an assault or other breach of the peace. And then there are specific illustrations, including subsection C, which you've just discussed, which engaging in noisy conduct tending to reasonably arouse alarm, et cetera. But those elements don't necessarily line up from the definition of disorderly conduct to subsection C. Do you read the statute as requiring all of the components, both the general definition of disorderly conduct and subsection C apply, or how do you read or is subsection C standalone?
Subsection C stands alone. There's a series of ors. And so disorderly conduct is one or more of certain acts, and two of those have been taken out. It's not engaging in brawling or fighting. It's not disturbing an assembly meeting or procession. So the city limits it to subsection C, and then also limits it within subsection C to this claim that there was noisy conduct.
Right. I guess my question is the introductory clause before you get into those, ABCs, also kind of defines the crime or the offense.
Yes.
And I just didn't know how we read that language defining disorderly conduct generally in conjunction with subsection C.
Okay, then, yeah, with regard to that, it is correct that the whole introductory first two lines are a part of the entire list of elements for the offense. So that here, the disorderly conduct is defined as actions of a person where that person knows or should have known, which actually creates its own additional problem, which has been argued below and amplified with the ACLU's brief on this mens rea requirement. Because a knows or should have known standard changes it from a requirement that a person behave intentionally or recklessly to they should have known something. And it gets even more diluted as you go through these particular provisions, because then you get to engaging in noisy conduct tending, which is a dramatically different phrase from intending to do something. So you're engaging in conduct that tends to more negligence kind of language, reasonably negligence language, arouse alarm, anger, or resentment in others. And then that ultimately what this boils down to is a combination of phrases that say if someone negligently engages in some form of conduct that might cause resentment, they have breached the obligation under this ordinance. How that is anything but content sensitive is hard to imagine.
How is it content sensitive?
If the noisy conduct causes resentment, the comparisons I draw are, well, there's the lack of time and place restrictions, which would be more typically found in trying to regulate noise types of conduct. But here, it is content driven, because if you consider someone who is listening to music in a variety of different contexts and different kinds of music in a variety of contexts, you might have someone listening in their family room to music at a high volume. If it's loud enough and it angers their neighbor, that's disorderly conduct.
Yeah, but it's the loudness, it's the decibels.
Well, there it's the loudness, but only because it's loud enough to cause anger. But if you get to the resentment section, you have someone listening loudly to music inside, outside, in a public forum like a park. And that might be, classics from the 50s, 60s, and 70s, or it might be someone listening to 1960s Vietnam protest music at a veterans park.
Doesn't the plain language of the ordinance make it pretty clear that the resentment is cabined by the noise level? In other words, it's not resentment because of the content of the speech. It's resentment because of the noise level. Which doesn't strike me as, I don't understand how noise level can be content.
No, because that is not what the language says, with all due respect. It is noisy conduct, whatever noisy means, tending to reasonably arouse alarm, anger, or resentment. It does not say engaging in conduct, the noise of which, or the noise level of which, or the decibels of which cause that problem.
Well, if we were to interpret the ordinance to cabin the subjective response, the annoyance or what have you, as related to noise only, would you agree that if that was the interpretation, it would be content neutral?
I think that runs afoul of the second of the two tests. One is this, is it content driven or content focused with things like causing resentment, causing anger? The other part is, can you reasonably sever those?
Well,
And even if you without gutting the language,
would you agree that that anger and resentment can be caused by pure decibel levels? In other words, I don't care what music you're listening to. It's just too darn loud.
well,
It's keeping me up at night, or it's interfering with my family dinner or whatever.
yeah, certainly anger as a response to the neighbor blaring music at all hours. That's one thing, but one of the things that the city does already is regulate noises with a time and place driven test of decibels, not driven by anger and alarm and resentment. And how does that resentment, how do you distinguish resentment because it's loud?
Well, you would have to prove it.
Yeah,
You would have to bring in facts that were
Yeah.
sufficient to meet your burden of proof.
You know, in the below and in your briefing, you agree that the parties agree that this is not content based, but it seems like that up here you're arguing that it is.
well, the language, the claim by the city is their action was not content based. This language is overbroad because irrespective of what the city says they want to do, it inevitably attacks content.
But that's contrary to what you argued below. And I mean, you agreed that it wasn't content based. So you're changing your position?
I guess I do not believe that's the intent of the argument below. The purpose of the challenge is the fact that this ordinance
Is overbroad.
is overbroad, and it's overbroad because the wording incorporates protected as well as unprotected content or conduct rather. And by casting that broad of a net, the language is inherently defective.
What protected speech does it sweep up?
I'm sorry.
What protected speech does it sweep up?
Well, protected speech or expressive conduct would be things that cause anger or resentment. Those could be,
Well, things that are of a decibel level that cause anger or resentment merely because they're that loud. In other words, put the question a different way. Is it your view that the First Amendment protects speech or conduct that is so loud that the noise level arouses anger or resentment in others? Is that your argument?
could you repeat that question?
In other words, that the First Amendment gives constitutional protection to volume, decibels. Because I have a First
Oh.
Amendment protection, you cannot regulate, you, the government, cannot regulate the volume of my speech or the volume of my content, which strikes me as a
Yeah.
classic time, place, manner
Yeah,
restriction.
and yeah, that is not what we are saying, because here we're focusing on noisy as opposed to what's the conduct and what's the function of that conduct, the impact of that conduct, which as worded necessarily impacts protected expression.
Can you give me an example of the protected expression?
Now, one of them, as I suggested, would be playing 60s and 70s Vietnam War protest music at a Veterans Memorial Park. That is just at whatever a noisy level is, that is just as likely, if not more likely, to fall within the language of this ordinance
So
as playing
this.
nursery
The
songs.
state is not allowed to impose a time, place, manner restriction on the decibel level of concerts in their parks.
Oh, no, I think they probably are. Unfortunately, this ordinance is not that ordinance. This ordinance is barren of time and place types of restrictions. It's barren of a description of even what is noisy. And the city has a noise ordinance, and the city has ordinances that affect interfering with traffic. None of which were invoked here, even though the purported purpose that the city based its decision to prosecute was a traffic regulation purpose, interfering with traffic. So the problem is the breadth of issues with a negligent standard, language that necessarily implicates expressive conduct, no way to ascertain what's noisy, no way to ascertain what conduct is across the line or on the safe side of the line, is why it's overbroad and why it needs to be stricken. Did you have an additional question, Your Honor?
You may have just answered it, that there are other issues to your overbreadth challenge, but the one Justice Stiegel is discussing. So if with this statute or the ordinance is interpreted to the reason, if we interpret it such that the reasonably arouse there must be a strict causation tied back only to the noisy conduct, does that cure that part of your overbreadth challenge? In other words, it's only tied back, the reasonable arousal has to be caused exclusively by decibel levels. Does that fix the problem? That particular line of overbreadth challenge?
Yeah, I suppose that could be considered to do that, but that is not a construction of existing language. That is a rewrite, because you have to clean up the mens rea problem in the first couple of introductory lines, the negligence aspect part of what's tending to reasonably do things, and then you have to simply ignore 3 words that are there, that are what ultimately leads to the overbreadth. And I think that goes beyond an authoritative construction to a rewrite, and it becomes a legislative matter that should be driven by the constitutional concerns of the citizens. My time is way up, so I appreciate your many questions, and I'll be back to see you at rebuttal time. Thank you.
Is there rebuttal?
I'm
My
not-
apologies.
I'm not
And I know
sure.
you mentioned it.
I'm not sure that you asked for rebuttal. I'm sorry. I often stop people and ask them if they mean to, and I did not do that.
We're okay with it if that matters.
That means that I actually took the instructions from you.
Mr. Shima, did I miss it or? Okay, thank you.
So I neglect.
Okay.
Thank you. And I guess with that resolved, my name is Nathaniel Johnson, Assistant City Attorney with Plaintiff Annapolis City of Wichita, hoping to address a few points for you all today, help with assessment of the case, and of course, answer any questions that come up along the way. Those points will focus on the plain language of the ordinance, and I might slip and say statute a few times because the language is the same in the city ordinance as well as at the state level. So this has statewide ramifications. That's why we have an amicus brief from the state. We'll also talk about how this language has been applied in the state of Kansas. This is not a new law. It's been around since 1969, so we have some history with it and how it's been
How was
applied.
the ordinance violated here? What led to it? I mean, it wasn't too noisy, was it? Or what was the violation?
Thank you, Your Honor. Yeah, and the noise played a part of it. There were megaphones, there was noise involved. The specific conduct was that noisy conduct spilling over into streets where protesters were not allowed to be based on where the police had set off sort of sections and barriers and things like that. But that wasn't even exactly what caused the problem. It was that there was an interference with traffic and the conduct of blocking traffic. If you look at the complaint that's cited in the first record of the volume on page first volume of the record, excuse me, on page 14, it shows that blocking traffic was the trigger that was used to determine whether there was noisy conduct, disorderly conduct.
And
that
blocking
happened.
traffic doesn't include any noise, right?
Not on its own, Your Honor, but there
Right.
is
So
also.
even though it's noisy conduct, there was no noise, right?
I don't believe that's true based on the record, Your Honor. The conduct involved sort of yelling next to the car, touching the car some.
Was
And-
there any evidence as to the volume level of the noise?
There was evidence that megaphones were used. There's not, that I'm aware of, specific evidence about the decibel level. And I got to circle back really quick that this is not really an as-applied challenge or anything going to the sufficiency of the evidence. So while all these are very good questions, I'm happy to entertain them. I don't think they get to the question of whether under Trotter, this is a facially overbroad
Okay,
statute.
so would you say that this is when just looking at the language, is it content-based or not content-based?
This ordinance and statute are not
Okay,
content-based.
and
They are
so what
content
is the
neutral.
city's interest? So if the restraint on speech is not content-based, it's your burden to show that it has an important interest in restricting conduct and reasonable in terms of time, place, and manner. What's the city's interest?
Of course, Your Honor. And I think that comes from the ordinance itself, that it's trying to prevent the type of conduct that would injure another or incite further violence.
Okay,
And
so
that-
yeah, in your brief, it says preventing verbal and physical confrontations.
With
Right?
the risk of escalating to violence. And I think that concept can be drawn by looking at other words in this ordinance. It refers to brawling, fighting, breaching the peace. When this court interpreted fighting words,
Right, so so you have fighting words in there already. What does the noisy conduct, engaging in noisy conduct tending to reasonably arouse alarm, anger, or resentment in others, what does that add to your interest in preventing verbal and physical confrontations?
sometimes, Your Honor, there are situations where conduct leads to breaches of the peace, incites potential violence. And I think this is maybe a good time to also look at some of the unpublished case law applying this ordinance and statute since 1969, where,
Give you a hypothetical.
of course, Your Honor.
Okay. Let's assume I have 10 friends. You know. Hypothetical.
Fully assumed, Your Honor.
I've got 10 buddies. We load up in a car. We go down to Broadway and First. And we burn an American flag while chanting as loud as we can, America, red, white, and blue, we spit on you. Can I be prosecuted under this ordinance?
I don't believe that you can, Your Honor,
How do I know that?
because it includes a reasonable person standard that itself dictates that things like protest and speech are not the target
I
of
know
this.
that. By looking at
It's
this,
tending to reasonably arouse alarm, anger, or resentment in others.
And
and I
Well-
assume that good people of Wichita love their country. So I don't see why that wouldn't arouse a response from the good citizens of Wichita.
And to get to the tending to reasonably, because I think that has to be a part of this answer here, that there is a reasonable person standard as part of this ordinance. And the word tending to reasonably, while I would not draft the ordinance or the state statute that way, seems clearly to invoke a reasonable person standard rather than a.
So you don't think a
tending to
reasonable
be
person
reasonable.
would be offended by that?
I think that under American constitutional law and the way that America functions, things like protest and speech do not cause resentment in a reasonable manner.
Let me take
And that-
Justice Biles' hypothetical. There is no geographical limitation in this, so it applies to all locations. So let's say that Justice Biles is doing this on his own property.
I'm sorry, I thought there might be more, Your Honor. My
Oh, there's
apologies.
not
And I
more.
think in that situation, there's less possibility there would be interference with people. Again, we'd need to demonstrate
His
evidence
neighbors.
of some,
Or
So-
maybe some of his friends are offended.
and.
Or not
totally-
offended, they are resentful and anger because they didn't know he was going to do that.
And that is true, Your Honor, but that subjective response is not what is
But
looked at
why-
under this.
Why can't
ordinance.
the resentment and anger just be related to the noise? In other words, change the hypothetical slightly. Again, whether it's in a city park or in his backyard. But Justice Biles has a tricked out, super truck with gigantic speakers arrays in the back, and he can actually broadcast his protest at, I don't know, 200 decibels. And why isn't that enough? And I'm struggling to understand why you would give that away as the city. I mean, doesn't the city have a legitimate interest? Many people wear Apple Watches now. I know I get noise. I mean, I get noise notifications now that, oh, your environment is too loud.
But
We
isn't
know
the city,
that can-
but the city's interest in that is covered by WMO 7.41, no noise ordinance, which is extremely long, which says it's unlawful to make all this noise with the decibels, which creates a nuisance or injures or endangers the comfort, repose, health, safety, or which interferes with others' use of or enjoyment of property or a person's reasonable sensibilities. So wouldn't that be duplicative of this?
I don't believe that it's duplicative, Your Honor. There was the interference with the motorist, the effect that this type of
But as you
conduct
said, this
had
is
on other
not,
people.
I'm talking about, I'm at a Chiefs game and I'm booing and cheering at a sporting event. And I'm, and my team, because I'm rooting for the Chiefs, has just scored a touchdown. And I'm talking about in a very loud way, how great my team is and how the other team isn't so great. That it tends to reasonably create resentment in others. I mean, I could think of a whole flipping somebody off in a car. I mean, all these things which are guaranteed by the First Amendment, you could prosecute me for all of these.
Your Honor, and there are other elements too under this ordinance that I think would affect.
What
that.
are the elements? What?
We've got so we've got a few different elements in the ordinance. The first is that there is a mens rea requirement. It is couched by the appellant.
Negligence.
It is couched by the appellant as negligence, but as the state points out in its amicus brief, that's not how this statute or ordinance is interpreted. It is a knowingly, intentionally, recklessly standard.
It says or should know.
And recklessly is should have known as well, but with disregard for others. And that's, as the state points out, how this statute has been interpreted in terms of a culpable mental state.
What case interpreted this as reckless?
There's not a case, Your Honor, but as the state argues in its amicus brief, and there's mirroring language in the city code as well, that when there's not a specific statement of negligence or laying out knowingly, intentionally, or recklessly, those are the standards that are used to determine a culpable mental state. And the known or should have known here.
Negligence is also a culpable mental state. And according to the model penal code, which I have right here somewhere.
And that may be true, Your Honor, and my apologies, I haven't reviewed that before this hearing, but at least according to the state statute, which is at 21-5202 KSA, it says that it requires proof the defendant acted intentionally, knowingly, or recklessly, and the city has the same requirement at 1.04.023 and code section 1.04.025. So it's not simply just a negligence standard, but there are also other elements that are part of this ordinance and statute that have been used to cabin or limit its application to the intended purpose. And that,
Back on my hypothetical,
of course, Your Honor.
because your response to me was, I'm okay because the city of Wichita is going to use a reasonable person standard when they prosecute me, which means that we have to go to trial, right? How else are you going to, otherwise, I'm just going to get hauled off and we'll see whether, we'll find out later whether a reasonable person would have thought that what I was doing was covered by this ordinance.
And
When
the
police
reason
officer drags me in, right?
I don't believe so. That's not how the city interprets or
I
applies
don't
the
care about
law.
that. I
unless-
care about the language of the statute. This is an over facial challenge.
Of course.
So it doesn't matter what you choose to do. I look at this, and if I know I've got to go to court to determine whether some of these loosey-goosey standards are going to apply to me, otherwise I'm in the Hooskow in Wichita jail, I might just decide I'm not going to speak. And that's the chilling effect that this, on its face, that this ordinance has, that as I see it. Now, what protects against that chilling effect? There's no standard there's nothing objective in any of this that doesn't have you going off to court to defend this.
And the city disagrees that there's not an objective standard as
And
discussed
so
before.
that's a
There's-
reasonable person.
Exactly, Your
We're
Honor.
going to find out at trial whether I go to jail or not.
The reasonable person standard is regularly used, though, to establish what type of conduct is criminalized or not, including even in something like noisy conduct or a noise ordinance for.
But not
city
necessarily
of
with the other
Wichita.
broad terms that you've got. And that's why this ordinance causes me to get animated, because it seems so vague that really, rather than, Miss Griffey, rather than do a Black Lives Matter protest again, is just not going to mess with it and stay home. And the First Amendment doesn't allow the city to have that kind of chilling effect if her conduct is constitutional.
There should not be a chilling effect, Your Honor, but this ordinance and statute, again, which have been around since 1969, do not create that chilling effect. The appellate court pointed out that the elements that I discussed here, particularly the culpable mental state, the way that a reasonable person standard is employed, to focus as well the actus reus, where there's only a certain kind of criminal conduct that is applied by this statute, establishes enough limits for it to be determined whether this is overbroad or not. And I think an important thing too is to come back to the question of what the standard is for a facial overbreadth challenge. It's one we use as a last resort, and there must be a demonstration that the potential application of this ordinance and statute overwhelms or is greater than in relation to the plainly legitimate sweep of this statute. And while there are definitely issues in how it could potentially be applied, that is true. There are definitely ways that we would potentially rewrite this, not include the word tending, but I think clearly this establishes a reasonable person standard, as again demonstrated by the unpublished cases that really tie it to the type of conduct that this is supposed to regulate.
If the
Is there a
city's-
definite,
Go ahead.
is there a definition of what makes conduct noisy? I just didn't see it in the ordinances or a cross-reference to the noise ordinances that Justice Standridge mentioned.
That's correct. There is not a cross-reference in this to the noise ordinance. And I think that's because it was based again on the state statute before we really detailed out our noise ordinance.
And has there been any case law interpreting what constitutes noisy under the state statute that would guide an ordinary person to know when their conduct has crossed that threshold, from
I don't believe so, Your
loud to
Honor.
noisy?
Yeah, the closest I have is that Smith case that I cited before, where the appellate court analyzed the noise ordinance and the language reasonable sensibilities to decide that was a reasonable person standard as well, despite inclusion of the word sensibilities.
Have there been any cases that you found where as far as the state statute goes, where people have been prosecuted by this part instead of the fighting words?
Other than unpublished, nothing published, Your Honor. The unpublished cases that we cited and that were also referenced by the appellate court a couple of them target the noisy conduct portion separate from the fighting words component of subsection C here, which hopefully I'm answering your question correctly.
Well, but those were all, okay, so which cases were those? I'm not have those. We have State v. Huffman, that's the big case.
There were a set of unpublished cases like Mead, Hughes, Hyder, and they're cited, I believe, in our supplemental briefing as well as the appellate court.
And what are
cited them
those,
as
what
well.
proposition do those stand for?
That this part of the ordinance statute, again, interpreting it at the state
statute.
level, is applied in a reasonable way and with a reasonable person standard that is able to differentiate between conduct and protected content. And the appellate court also pointed out that these cases really show also applying the Trotter standard, the plainly legitimate sweep of this ordinance and statute as well. And that's a really important part of this. It's not just potential infringements based on the First Amendment, but also balancing that or weighing that in relation to the plainly legitimate sweep of the
So
ordinance and statute.
Okay, so I get the plainly legitimate sweep of the statute as, fighting words. and preventing verbal and physical confrontations. So can you give me an example of unprotected speech covered by this ordinance that isn't covered by the fighting words provision?
Unprotected speech that's not covered by fighting words. I'm sorry, I'm not understanding the question, Your Honor.
Okay, so, so give me some examples of, legitimate sweep that isn't fighting words.
So in those cases, for example, there was belligerent activity in a library where someone was raising their voice and also very threatening to people.
Okay, so
There's a
fight,
few-
like what kind of threatening?
Just saying that they were belligerent, I believe, toward librarians, and then police that came in afterward,
Like
saying that
fighting
they'll
words?
fight them. Yeah,
Right,
But
so
not-
that's fighting words.
but there was also conduct involved, such as threatening people and moving toward them. And I think this case is,
But it was really wasn't about noisy conduct, really, right?
I believe it was. Those cases were more about sort of the conduct and being noisy and the way that ties to being belligerent and the risks that that poses to other people, rather than just using a word that itself
Okay, and other
causes the
examples?
injury. Excuse me, what's that?
Other I'm trying to differentiate because to me, you've got this legitimate sweep that it is covered under the fighting words. But to me, you've got this huge sweep that is covering all these other examples, political protest. Here, it could have been a conviction without the marching on the street. I mean, she could have been convicted. Anybody can be convicted for standing on a stage, content neutral, just using a megaphone. If somebody gets offended, not even by what the person is saying.
I don't agree with that interpretation of the ordinance or the statute, that just by speaking or by your content that you're able to be
What if it's
criminalized
about,
under the statute.
What if it's about, what if someone is standing up there? I guess you wouldn't even have to be noisy about it, but pumping with a gun. A lot of people would be, what are the words? They would be angered and resentment and alarmed.
But in that case, there wouldn't be noisy conduct. That
We
would
have a
cause any
right.
sort of
We
harm.
have a right.
And
We're here, whatever.
yeah, and the content of the speech is not a basis for conviction. And the prosecution would have to demonstrate that it was the activities, the conduct that created the fear that was sufficient to justify a conviction.
Okay, why wouldn't that fit? And even if it was content-based, why couldn't you still be charged under this statute?
And there are other elements as well. I mean, it's not taking action beyond the content that's trying to cause alarm or fear in other people, such as in this case where there was spillover into the road and interaction with the motorist.
Right, okay, but even I'm
those
talking
things
about
can
the
be separated.
political activity of, if you are if you are picketing at an abortion clinic, okay, why couldn't you be charged under this statute?
Sometimes there is disorderly or noisy conduct that occurs at abortion clinics, and I think sometimes that is
So you couldn't be
criminalized
charged.
as well.
Okay,
I think not as you described it, though. There was no noise necessarily involved, and it
what if
kind of
there's
depends.
noise? Because what's happening is
And-
you're making noise, you're engaging in noisy conduct, and you're arousing alarm, anger, or resentment in others.
Picketing does not reasonably cause alarm or fear.
Really?
That's correct. And I think that's because part of being in American society is understanding that things like content are not a reasonable basis for criminalizing or reacting in a way like that. And I think that's why the word conduct is included. The word reasonably is included, why there's a culpable mental state as well, that actions need to be taken with a purpose. And those kind of limits, again, have been used for decades to apply this law in a way without constitutional challenge previously.
We know the city of Wichita has noise ordinances that keep the streets quiet because you've got a decibel level and you can't go above it or you violate that. So you got that out there. You can
pass ordinances that keep people from blocking streets during time date. Why do you need this ordinance?
This ordinance protects against noisy, disorderly conduct. And that kind of conduct is different than things necessarily like traffic flow. And the traffic flow, like in this case, our ordinance, it was kind of iffy because there was some permission provided to the people to be on the streets. So it wasn't even necessarily that folks were on the streets protesting, it was the conduct or activity that occurred once they were there.
Why doesn't the opening part of the ordinance cover that? Disorderly conduct is one or more of the following acts. Action that would alarm, anger, or disturb. Why does it matter that it's noisy or? I mean, isn't that a broader category than having noise? Why do we need a noise category?
Oh, okay. My apologies, Your Honor. Well, noisy conduct is a type of conduct, and as alluded to before, where a certain decibel can potentially cause risks or fear of incitement. And when that is coupled with things like trying to incite fear or some sort of reaction that is not just content-based, that is the specific charge that the city is trying to deal with. And I think, again, this type of law has been applied quite a bit in Kansas and is used in various, and the jury found that the elements of this charge were satisfied in this case as well. So I think the prosecution correctly applied this charge here, and not to dive too much into it, but there were issues potentially with other charges that we could have brought as well. And also way past my time, but happy to answer questions, of course. Thank you, Your Honor.
Thank you to both counsel for your arguments today. We will take this matter under advisement.